Okay, so I realized that I haven't done any videos on right to travel in a long time, so in order to make up for that, I'm going to try and do a recap of all the right to travel cases I could find from 2019 in reverse chronological order. It might not be all of them. If it gets too long, I'll quit. First of all, we have Willie Cox Jr. out of Ferguson, Missouri. He's got a bunch of cases, like 3 or 4, so we're just going to discuss one. Keep in mind, all of them he lost. As we can see here, he was parked on the Quick Trip gas station lot when a cop pulled up, blah, blah, blah. Basically, he's suing over a parking ticket. So, what the court says is, plaintiff provides absolutely no factual allegations supporting the contention that an unconstitutional policy or custom exists. He also fails to present any facts that tend to show his constitutional rights were violated by Ferguson's failure to train or supervise employees. Most of his complaint is devoted to the dubious proposition that he has a constitutional right to travel unencumbered by state or local traffic regulations. This is insufficient to state a municipal liability claim. Therefore, plaintiff's claims against Ferguson must be dismissed. So that's, let's call that 1 loss instead of 4. Next up, we have Asher v. Birmingham Police Department. This is from Alabama, November. There's a bunch of stuff here, but this is the part that interests us. Asher alleges that officers Wesley and Guerrero of the Birmingham Police Department, Officer Gentry of the Vestavia Hills Police Department, racially profiled him in disrespect to his constitutional right to travel. In spite of the magistrate judge's orders to do so, Asher fails to specifically allege what each officer did to violate his rights. Documents attached to the complaint reveal that Asher received tickets from the officers for operating a vehicle without insurance and a license, failure to register his vehicle, or speeding. In response, this is a bit that we like, and state laws regulating speed on state highways and roads or requiring drivers to obtain and carry a driver's license and register their vehicles do not infringe on an individual's constitutional right to travel. See Hendrick v. State of Maryland, which covered Snavely v. City of Huntsville, blah, blah, blah. Maybe I'll read the Snavely. Conclusion, cases dismissed without prejudice, so another loss. For the sake of being thorough, I'm going to read Snavely. This is a case from Alabama, June 30th, 2000, and as we can see, it's still being cited in 2019, so this is still a good law. The cops stopped Snavely for driving without a license plate. He had a piece of cardboard with the word private written on it. Also homemade ID, etc. Here's the discussion that is relevant to this video. Snavely, I don't know how that's pronounced, I'm sorry, contends that the trial court erred in refusing to charge the jury on the definitions of transportation, carrier, driver, and chauffeur. He appears to argue that because his automobile is not a commercial vehicle, he should not have been convicted of the charged offenses, and that this is the typical commercial argument that people keep bringing up in the comments. Pursuant to Alabama code, every person who is not exempt is required to procure a driver's license before driving on the highways of Alabama. Although motor vehicle is defined clearly by Alabama code, Snavely focuses on the definition of vehicle in 32 defines a vehicle as every device upon which any person or property may be transported or drawn upon, excepting devices moved by human power or used exclusively upon stationary rails or tracked. Devices moved by human power are bicycles and that kind of thing, so you don't need a license for those. And stationary rails are trains. So Snavely draws that transported means that it's a commercial definition. The court disagrees with that and says it is a well-established principle of statutory interpretation that a statute should be read to give its its words, their natural, plain, ordinary, commonly understood meaning. Therefore, we reject Snavely's, feel really bad about pronouncing that Snavely wrong, strained interpretation, and we find no error on the part of the trial court. Next up, Snavely contends that the Motor Vehicle and Traffic Code restricts his constitutional right to travel. Specifically, Snavely appears to argue that the fee charged to obtain or renew a license or to register a vehicle constitutes a tax upon his right to travel. And here is the discussion of that clip. Although there is a constitutionally recognized right to interstate travel, that right does not include the unregulated use of the state's highways. While a state cannot penalize a citizen for exercising his right to travel between states, a state may regulate its public highways and impose reasonable regulations for securing the safety of travelers using those highways. And they cite Hendrick v. Maryland, which I've mentioned previously, which holds that it is an acceptable exercise of a state's police powers to require licensing of their drivers and registering of vehicles and to charge a fee to implement those requirements. They also cite another case, RTN v. State, recognizing that the state of Alabama has the authority under its exercise of police powers to regulate motor vehicles on public highways and to impose reasonable fees to implement a policy, and cites other stuff. Because it is a privilege to operate a motor vehicle on public roadways, and because licenses and registration and the accompanying fees are not taxes, but an exercise of the state's police powers to ensure safety on the public highways, the regulation and its accompanying fee do not inhibit your right to interstate travel. Therefore, we conclude that the state's requirement that he renew or obtain a license and register his vehicle place no impermissible restrictions on Snavely's right to travel. So, as you can imagine, he lost. And this is from Alabama, so if you try to say that you have the right to travel without a license in Alabama, this is the case that they're probably going to cite. Other 50 states have similar cases that they cite. Next up, we have L.V. Fernandez, South Carolina, November 22. This is gonna take a while. We're only up to November. This past August, plaintiff was pulled over and arrested for failing to pay child support, driving without a license, driving without insurance, and driving an unregistered vehicle. Plaintiff, who proclaims to be a Moorish national, I figured we would find it more eventually, alleges defendants have kidnapped him and thus violated his rights. There's discussion of the Moorish stuff, which, yeah, well, I'm just going to read the good parts. The Moorish nation is not recognized sovereign state, and people claiming to be Moor or Moorish Americans are not immune from the laws and rules imposed by the United States or the individual states. And they cite a bunch of cases that basically determined that. But anyways, this is the right to travel bit. Plaintiff alleges that he has a fundamental right to drive as he pleases. Speeding, running stop signs, and driving an unregistered vehicle pose no threat to public safety, and so arresting someone for such conduct is illegal because it infringes upon the right to travel. In that same vein, he alleges police cannot use outstanding bench warrants to arrest drivers because that violates the right to travel. Those assertions are frivolous. Courts have squarely rejected the notion that there is a fundamental right to drive, finding meritless, and there's no such right. There's no such right. Claims that you have the right to travel without obeying vehicle laws are frivolous. Blah, blah, blah. For those reasons, the complaint is subject to summary dismissal for being frivolous. So another loss. Next up, we have Romagnano v. Childers. I am very sorry about the pronunciation of these names. This is from Florida, October. By the way, keep in mind, a lot of these are pro se. Okay, so here's the good stuff. Plaintiff allegations against the defendants relate directly to the traffic citations he received and thus are intertwined with the state court judgment and sentence. Here, plaintiff has not alleged any deprivation of a fundamental right, much less a deprivation caused by any act or omission of the defendants. Indeed, the constitutional right to travel does not include a fundamental right to drive a motor vehicle. As Newman, a bunch of cases, you can see them. Hence, the suspension of a driver's license issued and suspended under Florida law does not implicate any substantive due process rights. Plaintiff thus failed to state a viable substantive due process claim. As you probably expected, dismissed with prejudice, another loss. Next up, we have another Moore, this time Connecticut, October. Naid L, ex-relation Diana Dawes, etc. The whole name. She is, or he is saying, plaintiff requests that this court intervene in state action to reinstate her driver's license and vacate fines levied against her. Plaintiff also demands money damages and costs. Finally, she seeks injunctive relief and declaratory relief, finding that Connecticut's statutes and mandating the registration and insurance of motor vehicles is unconstitutional and prohibiting the imposition of penalties for failure to register or insure individuals not engaged in commercial activities. We get some background here. On April 7, 2016, she pulled a motor vehicle into a private highway driveway who admitted she did not have a automobile insurance, and she got a citation for that. She was found guilty of operating a motor vehicle without insurance and imposed a fine of $290. And then there was restoration of license, whatever. Here's the good stuff. Plaintiff alleges that the state cannot require her to register or insure her vehicle because she is not using the vehicle in a commercial capacity. This is, again, the commerce argument. Specifically, plaintiff contends that the government cannot require private citizens not engaged in commercial activity to register or insure their vehicles because that would infringe on their constitutional right to travel and the United States Motor Vehicle Safety Program. As you can imagine, it was dismissed in its entirety for lack of jurisdiction, and as a result, they did not discuss the right to travel stuff, fortunately. Next up, we have Brown v. Scott. This one is in Kansas, October 9, 2019. We have pro se plaintiff Kevin Brown. He was alleging false arrest, unlawful stop, searches, and arrest. He also cited several federal statutes without explanation. Also attached to the complaint were several documents, including his oath of office. That's a good one. Plaintiff's traffic ticket, certified mail returns, IRS Form 56, notice of declaration in the form of a commercial affidavit of truth, writ of a freeman's right to travel, a legal notice, and demand fiat justitia ruit, Salem, I don't know, a property receipt record for plaintiff. Plaintiff's traffic tickets list 6 violations. They include driving in excess of the speed limit, driving with a suspended license, covering his license plate with with an opaque material. As best the court can discern, they can't even understand what the guy's saying. Plaintiff brings claim against the Kansas Highway Patrol officers who arrested him for traffic violations, the prosecutor, and the judge. There's a long discussion, but this is a good part. It appears plaintiff's complaint asserts that he is not subject to jurisdiction of the state of Kansas while simultaneously calling upon the court to enforce his agreement. 10th Circuit specifically has rejected a litigant's attempt to declare sovereign citizen status to avoid jurisdiction of the courts. Plaintiff cannot state a claim based on a frivolous argument with no conceivable validity in American law. The court thus finds that plaintiff has failed to show good cause why the court should not dismiss his action, and was dismissed as you go. They're all going to be dismissed, so I should probably stop saying that they were dismissed. Next up, we have Commonwealth v. Zumzum. Why do they all have to have weird names? Okay, this is Pennsylvania, October 2019. Stuart Kent Zumfi appeals from the judgment of sentence entered after a trial court found him guilty of 9 summary offenses related to his operation of a motor vehicle. Anyways, this is the bit that relates to this video. In the second question presented, appellant would have us agree that his constitutional right to travel is not superseded by the Pennsylvania Motor Vehicle Code. A trial court's application, As the Commonwealth points out, appellant does have a right to travel. Freedom to travel throughout the United States has long been recognized as a basic right under the Constitution. The right to travel includes the right of citizens to enter and leave another state. The Commonwealth continues. The Supreme Court has also long recognized the power of states to regulate the use of motor vehicles, including the states requiring that individuals properly register vehicles and obtain driver's licenses. In Pennsylvania, the Motor Vehicle Code governs the use of motor vehicles for protection and promotion of public safety and property within the Commonwealth. Appellant's use of a motor vehicle is governed by the Motor Vehicle Code, and its right to travel within the United States was not implicated. We discern no error of law. Appellant's second issue lacks merit, and obviously be lost. Next up, we have State v. Covington. This is Hawaii, October. We have Robert Covington. No, that's wrong. Yeah. Oh, yeah. Robert Covington Jr. He's appealing. Whatever. He was found to be in violation of the no-fault insurance statute, conditions and operation of motor vehicles. Covington says 5 points of error, contending that the district court erred in convicting him because 1, the conviction violates his right of personal freedom; 2, the conviction violates his right to travel; 3, he did not operate a vehicle; 4, the convictions violate his right to due process; and 5, the conviction converts his right to travel into a criminal act. And this is a common argument that people bring up in the comments, so it's good to find this kind of stuff. We first address Covington's argument supporting his third point of error, which is that he was a traveler, not an operator, because he was not using the road as a place of business, nor was he using the road for personal economic gain. As the state points out, however, the no-fault insurance statute requires that all vehicles, commercial or private or otherwise, must be insured. Covington cites no authority to the contrary, and we find none. So again, saying that you're a traveler, not an operator, doesn't work anywhere. Covington submits that his constitutional right to travel were violated because he has the right to travel on public highways by a motor vehicle. Covington was not giving essentially, the same arguments were raised and rejected by courts in State v. French from 1994. So obviously, the judgment was affirmed, so this was a loss. And you know what? I'm going to read State v. French just for fun. Okay, so this is State v. French. This is the case that the judge is going to cite if you try to use right to travel arguments in Hawaii. I probably shouldn't have to explain this, but in the United States, there is dual sovereignty. State Supreme Court, state appeals courts apply to lower courts within the same state. So all 50 states are going to have different versions of case law that's basically say the same thing. Finally, defendant argues that the traffic statutes involved only apply to businesses and state vehicles, not to a sovereign individual who utilizes his vehicle for personal needs. This is basically the commercial argument. He further maintains that if the statutes do apply to him, they would violate his right to travel. The statute, and this is the court's response, the statutes in issue do in fact apply to individuals who use their vehicles for personal needs. And they cite the law, every owner of a motor vehicle used or operated at any time upon any public street, road, or highway of the state shall obtain a no-fault policy. Emphasis added, owner of a motor vehicle means a person who holds the legal title to a motor vehicle. Person, in turn, is defined as not only individuals, but corporations, firms, and societies. Respect to count 2, no person shall operate a motor vehicle, blah, blah. With respect to count 3, operate, da, da, da. Finally, this court sums it up. None of the provisions limit their application to vehicles used for state or business purposes only. The statutes apply to persons, and a person is defined in general usage as a human being, i.e. natural person, and whoever means whatever person. As a result, on their faces, the statutes apply to defendant. Having found that these statutes do apply to the defendant, we turn to the authority underlying these traffic laws. As part of the exercise of his police power, the state may, in the and they quote Hendrick v. Maryland, and they cite Hendrick v. Maryland, which is the federal Supreme Court case from 1914, which all the states cite, giving them the right to regulate the operation of motor vehicles in connection with the offenses charged. And it allows them to prescribe uniform regulations and fees. Specifically, in Hawaii, it says that the Supreme Court of Hawaii has recognized the right to freedom of movement. This right includes the right to move from place to place in the fields or the street. Yet, this right is too subject to police power to regulate an individual's conduct for the protection of society. That being so, pursuant to its police power, the state may regulate the operation of motor vehicles for safety and order of the general public. Thus, statutes similar to the ones here are commonly held to be constitutional because the requirements imposed on the operation of motor vehicles are rationally related to the purpose of the statute. So, a lot of people get confused about this in the comments or are pretending to be confused. Yes, you have a right to movement, but that right can be regulated. And they even cite another interesting case here. Religious belief that one should be able to drive unhampered by local traffic laws does not prevail over the state's police power, and this got lost in 1993. Next up, we have Hunter v. Doe, September 2019. This was in Idaho. Further, in his complaint, Hunter includes a memorandum of law as an exhibit in which he appears to allege that the defendants violated his right to travel, which he believes is synonymous with the right to a driver's license, but the court cannot be sure that this is what he is actually alleging. And basically, because the court couldn't figure out what he was trying to say, it got dismissed. So basically, another loss. Next up, we have Robinson v. Pintez, September. This is from West Virginia. This is another Moorish case. Olajuwon Robinson and Reggie Robinson L. Here, the complaint alleges cause of action under the 4th and 5th Amendment in relation to a traffic stop. There's discussion of the Moorish stuff. Plaintiff's claims relate to a Moorish nation jurisdictional theory that courts have routinely rejected as frivolous. There's a whole bunch of stuff which I won't get into because that will just get too long. Anyways, this is a part that relates to this video. The complaint states that the plaintiff informed the defendant of his intent to exercise his right to travel the streets and highways freely without fear of detainment, harassment, or molestation. According to plaintiff's statement of facts, defendant Morgan laughed and told him that he watches too much Facebook. The other vehicles that was placed in the back of a police car until his father arrived on scene. And then there's discussion of the basics of it. It is well settled that a law enforcement officer has the authority to stop a motor vehicle and conduct an investigative detention when reasonable and articulable suspicion exists that an individual is engaged in illegal conduct. There's no question that West Virginia law requires the vehicles to be properly registered with the department and that the registration and license plate must be displayed on the vehicle. It is unlawful for a person to display a fictitious plate. Motorists must be licensed and carry their driver's license, so obviously another loss. Next up, we have Williamson v. State, August 29, Indiana. This one looks kind of good. Edgewood police officer observed a white pickup truck pull into a highway. He ran a BMV check of the license plate and learned that there was a protective order. Observed the truck come to a stop and stopped and failed to signal prior to turning right. Looks like you mentioned something about Williams asked, what about the right to travel? Explained that it was an issue for trial. There's no actual discussion of right to travel here, but his conviction was upheld, basically. This was for resisting law enforcement as a level 6 felony and driving while suspended as a class A misdemeanor. Next up, we have Ahmed v. Ohio State Highway Patrol, August, obviously Ohio. Before me by referral is Abubakar Ahmed's pro civil rights, blah, blah, against the Ohio Turnpike and infrastructure. There's a whole bunch of stuff. This is the part that relevant to this video. Ahmed provides no factual allegations that he is part of a protected group, nor that the actions taken were done for a discriminatory purpose. Substantive due process. Although a substantive due process right exists to travel, that right is subject to government regulations such as enforcement of vehicle laws, and they cite U.S. v. Hare. The constitutional right through a state is not a right to travel in any manner one wants free of state regulation, and does not give a person the right to ignore traffic laws at their discretion. And this is, as you can see, this is how long it gets. As noted, finally, as again, the constitutional right to travel through a state is not a right to travel free from state regulations, nor does it give a motorist the right to ignore state traffic laws. What remains is that Ahmed is dissatisfied that he was pulled over for a traffic infraction and further subject to a vehicle search after a drug enforcement canine gave a positive sign. That does not state a claim that he was in any way denied the right of interstate travel. So, dismissed with prejudice. Next up, we have an interesting one. This is OwnerOperator Independent Drivers Association, Inc., along with a whole bunch of people against, Pennsylvania Turnpike Commission. Yeah, personnel. This isn't technically right to travel, but whatever. Plaintiffs claim that the tolls violate their right to travel. Basically, to determine whether state law impinges upon the right to travel, the challenged law's primary objective must be to impede interstate travel. And in response to that, they say, this is what the court says: burdens on a single mode of transportation do not implicate the right to interstate travel. This is basically one of the main arguments. Just because there's a burden on driving by a car, you can drive other ways. Moreover, burdens placed on travel generally, such as gasoline taxes or minor burdens impacting interstate travel, do not constitute a violation of the right to travel. Minor restrictions to travel, including delays and costs, simply do not amount to the denial of a fundamental right that can be upheld only if the government has compelling justification. The right to travel cannot conceivably imply the right to travel whenever, wherever, and however one pleases, even on roads specifically designed for public travel. So another loss. Next up, we have Gloria Sun Young, or however that's pronounced, versus State of New Jersey. This is from July. It's a pretty long thing, but the key one here is that she claims that the judge had no jurisdiction to issue a warrant for failure to appear because she has a constitutional right to travel, and it's a pretty complicated thing here. Basically, Mrs. June's claim largely revolved around her contention that she is a sovereign person and as a result, she is not bound by state statutes, including motor vehicle laws. Basically, they cite a case that rejects a claim in connection with traffic stop in which plaintiff presented sovereign identification instead of a driver's license, and saying that claims that the defendants have no authority to incarcerate him because he is a sovereign citizen are apparently frivolous. And as a result, the allegations by Yoon Jeon failed to state a claim and are dismissed as frivolous. Next up, we have Falls v. State, July, Indiana. This isn't technically a sovereign citizen right to travel. It's interesting, but it relates to this kind of. This guy, Rodney Falls, was found guilty of level 6 felony stalking, and he used a right to travel argument. He said that right to travel is a constitutionally protected activity, and as a result, laws against stalking violate his right to travel, which is funny. But anyways, here's what the court said about that one. The right to travel is not unlimited, holding that a chilling effect on travel. Other considerations may outweigh an individual's interest in travel. For example, an individual may not operate a motor vehicle without an active driver's license, or while he's drunk, or with open alcoholic beverage containers, or without proper registration. You may not use public roads to transport someone to promote human sex trafficking. An individual may not forcibly kidnap or transport a child by using a vehicle, blah, blah. So this is one of the things we were saying. Yes, you have a right to travel, but it's not unlimited. The government can put limitations on your travel, including, again, licenses, and not using your car for sex trafficking. Next up, we have Wellington v. Foland from New York in July. This one is a sovereign citizen. As you can see here, pro se, that's a red flag right there. Most of his complaint is rambling, far from clear, and contains virtually no factual detail. Construed liberally, the gravamen of plaintiff's complaint is that he is a freeborn and sovereign individual. He claims that his rights were violated by a whole bunch of cops. It appears that his claims center around 2 traffic stops that resulted in arrest in October. He alleged that he was arrested in October and had his vehicle towed. He posted bail and was forced to pay towing $400 to get his property back. That's one of the things these guys don't mention. The fine might be small, but the towing fees are way larger than the fine sometimes. Anyways, he claims that he was deprived of his right to travel, Fifth Amendment, and a bunch of other stuff. This is the bit that is related to this video. The Constitution protects the fundamental right to travel within the United States, which we have also called the right to free movement. This is case law for New York. Again, each state has different case law, but with respect to this issue, they all say the same thing. The right to travel accomplishes blah blah. Anyways, as the judge explained, plaintiff's allegations regarding his right to travel relate to traffic stops and arrests. As a result, I recommend that plaintiff's first claim be dismissed for failure to state a claim. And he cites Schultz, whatever, dismissing a complaint, including his right to travel claim, where the complaint alleged that the police department harasses me when I drive in my private vessel, non-commercial private use only, rightful use of American easement. So again, the old commercial argument. As you can probably imagine, dismissed with leave to plead. Next up, we have John Henry Doe v. Mower County Sheriff Office. He claims that his freedom of movement and right to travel freely was violated after he was stopped outside the Alston Police Department and given a citation for driving without a valid license. Unfortunately, there's no discussion of the issues here because, as you can see here, he filed this John Henry Doe. He filed the lawsuit anonymously. I think this is the first time I ever see this. And as you can see here, the Federal Rule of Civil Procedure requires parties to identify themselves. You can't sue anonymously, so the case was dismissed on those grounds. There's no discussion of the right to travel stuff. Next up, we have Stout v. City of Everett in Massachusetts, July. Stephen Stout, he's suing chief of police and a whole bunch of other stuff. He was driving on Revere Beach Parkway and he got pulled over. And he got a citation for driving on a red light. He paid a $105 fine. Basically saying that his right to travel freely was deprived. There's no discussion of right to travel, but it was dismissed. Next up, we have Larry Wise v. Ryan Morrow. This one is Michigan. We're still up to July. This one is a sovereign citizen case. State police seized and searched his vehicle in July 2017. He had a homemade license plate. He declined to provide a driver's license. He ran the vehicle, and the vehicle was uninsured. Here is the plaintiff's argument. He says that if a citizen is not engaged in commerce or using roads for profit or gain, and the commerce argument does not request, the citizen has retained their right to travel under the common law upon the public public roads without regulations. Anyway, this is a bit about right to travel. Although the Supreme Court has recognized a fundamental right to travel, that right does not embody a right to a driver's license or a right to a particular mode of transportation. League of United. That's the case law for where was this? Excuse me, Michigan. So yeah, you have the right to travel, but you don't have the right to travel in a specific way. In this case, car. As you can see here, he lost. Motion was denied. Next up, we have LB v. Perkins. This is Louisiana, July 2019. This is another Moorish case. The document indicates that it is entitled for filing in the International Criminal Court. Mentions the Moorish National Republic. Blah, blah, blah. Plaintiff alleges that he pulled over, presented his Moorish American identification and right to travel paperwork to the officer. And as the usual fun Moorish language, human trafficking of my flesh and blood. Obviously, it was dismissed, and here's a good bit. Persons charged with crimes sometimes contend that they have special status stemming from their association with a Moorish group that somehow exempts them from prosecution. One court recently described this as an uniformly discredited and utterly baseless notion. As you can see here, it was dismissed without prejudice. Another loss. Next up, we have Ank LDbutz. This is from Indiana, June 27. Jesus. There's a whole bunch of stuff here about foreclosed property and stuff. We're not going to get into that. Ank L argues that he is not required to have a driver's license because he has a fundamental right to travel. Considering this argument, the Indiana Court of Appeals held that neither this court nor our Supreme Court nor the United States Supreme Court has ever held that there exists a fundamental right to drive a motor vehicle. This is not an unreasonable application of constitutional law, and that's the only discussion of right to travel. Obviously, denied. As you can see here, his habeas was denied. And if you're wondering what the what he got here, jury trial, he got guilty on all counts. theft as a Class D felony, count 4, trespass as a Class A, count 1, burglary, felony, driving while suspended. That's it, got 2 years, no, concurrent sentences, 4 years with 2 years executed through community corrections, blah, blah. So a huge loss there. Next up, we have Douglas Arthur Walsh Lager v. Jeff Gast, May, Michigan. Another Michigan case. Anyways, 15-page complaint against 20 defendants. He claims that on July 27, 2015, he was kidnapped after defendant Ben Eberly asked to see his driver's license. Plaintiff claims that he's not required to have a license, relying on self-styled common law vehicular judicial notice constitutional driver's license, which grants him as a sovereign common law citizen the right to travel and not be infringed. He's suing for $39 million. As you get, there's plaintiff's complaint is totally implausible, unsubstantial, frivolous, devoid of merit, and no longer open to discussion. And the complaint was dismissed. Next up, State v. Williamson from April in North Carolina. He was driving his pickup truck southbound. There was a accident. He was cited for driving without license or failure to reduce speed. Basically, he argues that the trial court erred by not addressing constitutional challenges. It appears that the defendant sought to challenge the constitutionality of the statute, which prohibits driving upon the highways with a revoked license. The defendant argued to the trial court that this impeded on his right to travel. However, the court rejected a similar argument in Sullivan involving a constitutional challenge, which makes it unlawful to drive an unregistered vehicle on the highway. This court noted that the right to travel is not synonymous with the right to operate a motor vehicle on the highways of the state. And we have the standard quote from Hendrick v. Maryland. A state may rightfully prescribe uniform regulations necessary for public safety, blah, blah. The appeal was denied as easy. Next up, another Hawaii case, April 1st, Hawaii, Requinio v. City of Hilo. This is a bit that deals with that. Defendant asserts that the officers violated his common law right to travel, and the court dismissed that without any discussion. Another Massachusetts case, this one from February, Libous v. Baker, Ilya Libous. See here, this is the relevant bit here. See, right to travel. Libous contends that the defendants deprived him of his fundamental right to travel because of the suspension and non-renewal of his Massachusetts driver's license. However, enforcement of state motor vehicle licensure requirements does not violate the United States Constitution. The Supreme Court has recognized the constitutional right to travel. However, the constitutional right to travel guarantees the right to cross borders into another state, blah, 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 but not the right to drive a car without a license. The right to travel protects how a citizen in a state is treated by the government compared to other citizens in that same state. Libous has not alleged any action taken by the defendants. So as you can see here, he lost again. Next up, we have State v. Stevens, January, finally. This is New Jersey. He was convicted of driving an unregistered automobile on a public highway. The conviction was affirmed. 3 vehicles were obstructing traffic. They summons. I saw that the registration had expired. Anyways, here's the relevant bit. Defendant has argued throughout this matter that he was not required to register his automobile because Title 39 only applies to motor vehicles used for commercial purposes or the conveyance of persons for hire. This is, again, the commerce argument. He also violated his right to travel. They get into his claim. The court discusses his commercial claim, saying that defendant misinterprets New Jersey motor vehicle laws. The registration requirement provides in pertinent part, except as hereinafter provided, every resident of this state and every non-resident whose automobile shall be driven in the state shall, before using the vehicle on the public highways, register the same, and an automobile shall not be driven unless registered. The term automobile includes all motor vehicles except motorcycles. The term motor vehicle includes all vehicles propelled otherwise than by muscular power. Thus, all motor vehicles used for the conveyance of persons for hire, pleasure, or business must be registered if driven by a resident or non-resident of the state. Defendant used his vehicle for pleasure, thus his vehicle was not exempt from the registration requirements under New Jersey state law. He was required to register the vehicle if he drove it in this state, whether he was resident of New Jersey or California. He violated by driving an unregistered motor vehicle. So there we go. In plain English, black and white. If you use your vehicle for pleasure, it needs to be registered. Supreme Court of the United States has long recognized the power of the states to regulate and require the registration of motor vehicles. And as always, they cite Hendrick v. State of Maryland. And they also cite, I think I mentioned this, Kane v. New Jersey. The power of the state to regulate the use of motor vehicles on its highways has been recently considered by this court and broadly sustained. It extends to non-residents as well as residents. Our Supreme Court, this is the New Jersey Supreme Court, held that license requirements do not impose a direct and material burden on interstate commerce. It constitutes a reasonable exercise of the police power for public safety and order in a field not occupied by the federal authority. The power of the state to regulate the use of motor vehicles on its highways extends to non-residents as well as non-resident. There's a whole bunch of other cases. In addition, we have noted the United States Supreme Court has emphasized that the states have a vital interest in ensuring that only those qualified to do so are permitted to operate motor vehicles. These vehicles are fit for safe operation, hence that licensing, registration, vehicle inspection requirements are being observed. Accordingly, the registration requirements do not violate the defendant's constitutional right to travel. We also have Cormack the Hollenback, January. Again, this one is from Kentucky. He claims a affidavit of sui juris state right to travel. And what the court says is that his claims are premised on sovereign citizens' theories, which have been uniformly rejected by courts, and as a result, it was dismissed, so another loss. Next up, we have BEM, the City of Cedar Rapids, Supreme Court of Iowa. Ooh, that's a good one, Supreme Court. As we hear, this is about automated traffic enforcement and other stuff. This isn't technically a sovereign citizen case. It's about automatic speeding fines, but it deals with the same issues here. AT ordinance in this case infringed. We do not find the ordinance infringed any right to travel. Term infringement is a term of art with some ambiguity, but clearly does not mean anything that impacts travel. If traffic regulations infringe the right to travel, there could be no traffic regulations, and no one, however, can seriously question the power of the state or municipality to impose speed limits on its highways. It mentions Mower v. Supreme Court, noting that speed limits do not directly impinge on the fundamental right to travel. Speed limits do not have the function or purpose of penalizing or discovering travel itself, and do not impose substantial burdens on the traveling public. They also mention Kramer v. Skinner, which emphasizes that minor restrictions on travel do not amount to denial of a fundamental right. Read that again. Minor restrictions on travel does not mean that your right is being denied. They can put they can apply minor restrictions on rights. The idea that a lot of people that comment saying, "Oh, you have the right to do or travel," think that the government can't place any restrictions. That is not true. It's not surprising the courts have considered the validity of the ATE systems, not found the right to travel, infringed by the enforcement. You can see these guys lost. Next up, we have Blakely v. Andrade. This is from Texas, January 23. This one is a sovereign citizen case. Details actually get kind of good. He claims that the deputies initiated a traffic stop on the vehicle the husband was driving because the rear license plate light was not working. That's interesting. I didn't know about license plate lights. Well, anyways, the husband handed Smith his driver's license and handgun license. He declined to get out of the vehicle because he had not committed a crime and he was not in the commission of the crime. I think if you follow this channel, you know what the problem is there. You can't decline to get out of the vehicle, unfortunately. They're probably going to discuss it. He reached into the vehicle and attempted to unlock the door, but the husband defended himself. Deputy shouted for husband to get his expletive out of the vehicle, assaulted him, blah blah, a whole bunch of details. Anyways, he was arrested for unlawfully carrying a light firearm while intoxicated, and a bunch of other stuff. This is relevant bit here. He argues that Section 547 of the Texas Transportation Code is not positive with law, nor does the code apply to him. He contends that he has a natural right to travel without government interference. The court's response is, courts have held that driving an automobile on public roads is not a constitutionally protected right, but a privilege. This is Perkins, whatever. A license or permit to drive an automobile on public highways and streets is a privilege. It is within the state's police power to reasonably regulate any who use public roads. Let me read that. It is within a state's police power to reasonably regulate any who use public roads. It's not limited to people doing commerce. In order to protect the welfare and safety of the general public, blah, blah. And they mentioned the Texas law, providing that vehicles shall be equipped with at least 2 tail lamps, including a separate lamp used to illuminate a rear license plate. I didn't know about that. See, you learn stuff from reading this. Husband cites no authority to support a finding that statutes providing for general lighting requirements violate constitutional provisions. And so we lost. Anyways, the specific bit about right to travel was dismissed. Other stuff was is still being dealt with. Next up, Profit v. City of Shaker Heights, January, Ohio. This is another Moorish guy. Plaintiff describes himself as a Washita de Doug de Mount Ya Moor national. Plaintiff asserts that while driving his vehicle in Shaker Heights, stopped him for driving through a traffic sign, expired license tags. He said that he did not have a driver's license. He said he was not a citizen of the United States. Ohio's laws did not apply to him. He was native. Presented him with a right to travel card. To summarize what the court said, plaintiff's claims are frivolous, specifically in the things about, by virtue of claim to several parcels of property in Michigan by virtue of their Moorish ancestry is baseless, fantastical, and delusional. And they cite the right to travel freely does not exempt plaintiff from compliance with laws of Ohio. There's a lot more discussion of the Moorish stuff, but at the end it all got denied. This isn't a sovereign citizen case, but I find it interesting. He was convicted of second-degree burglary, receiving stolen property and possessing burglary tools. One of his release conditions prohibits him from possessing burglary tools and spark plugs. Cook argued that prohibiting him from possessing spark plugs impinges on his right to travel by exposing him to arrest anytime he enters into a vehicle with an internal combustion engine. And they respond that actually the prohibition only prohibits him from having spark plugs for use as a burglary tool. That's interesting. I didn't know that you could break into something with spark plugs. Anyways, relevant to this video is that such a limitation cannot plausibly be seen as impinging on his right to travel. Quote, burdens placed on travel generally, such as gasoline taxes, or minor burdens impacting interstate travel, such as toll roads, do not constitute a violation of that right. Denial of right to drive did not unconstitutionally impede right to interstate travel. Again, so he lost. The judgment was affirmed against him. Now, finally, we have State V Simmons. This is from December 2018, so finished 2019. So this is going to be the last one. This is a guy that was stopped drinking and driving. Anyways, discussing right to travel. As an initial matter, the requirement of a driver's license and the revocation of a license do not run afoul of the constitutional right to travel. As the Court of Criminal Appeals has explained, this court agrees with appellant's contention that he enjoys a fundamental right of freedom of travel. However, appellant's right to travel has not been infringed upon by the requirement by our legislature that an individual have a valid driver's license to lawfully operate a motor vehicle on the public highways of the state. Also, in another case, the ability to drive a motor vehicle on public road is not a fundamental right. Instead, it is a revocable privilege that is granted upon compliance with statutory licensing procedures. Mr. Simmons' argument that the revocation of his license under the implied consent will violate his right to travel is therefore unpersuasive. So, as you can imagine, he lost. Judgment was affirmed. So, to summarize, in 2019, in all 50 states and territories of the United States, there was not a single successful right to travel case. Nobody has won arguing that he has the right to use their car on public roads without a license. So that's 2019 ended.